Hi, this is Erica Merrill, and I'm the founder of Perfect Legal Video. I'm very excited to bring to you attorney Blair Boyd from the Sorensen Van Leuven Law Firm out of Tallahassee, Florida. They handle cases for credit unions of all types. And today we are going to be talking about a really interesting topic. It's how to handle set-offs when they pertain to your members going through a bankruptcy. Welcome today, Blair. Thank you so much for joining us.
Thank you, Erica. Thank you for having me.
You are welcome. So let's talk about what is a set-off?
I wanted to talk about a subject that I get a lot of questions on, and that is the credit union's ability to set off funds from members' accounts after they have filed bankruptcy. Now, this is a tool that credit unions should know is available to them to give them the ability to set off against any loss that they may face once a member files bankruptcy. Now, there's a big scary phrase that everyone's told at a credit union when it comes to bankruptcy, and that is the violation of the automatic stay. Now, no one wants to tell their supervisor that the credit union has been sanctioned for a violation of the automatic stay, which I think is one of the reasons I see credit unions become hesitant to take actions that can help them. And set off of funds is one of those areas and actions that I see hesitancy in taking. So this is why you need to know your rights so you don't find yourself in that situation. So in dealing with set-offs, the first big step that you need to do is identify which funds qualify for a set-off. Then you can move forward with trying to get those funds.
Wow, that's really interesting. And it's great to hear that the credit unions have some kind of way to get their funding back, even if their member is going through bankruptcy, so that they don't have to lose so much. I mean, they are a business, and if every one of their members goes bankrupt, that could actually bankrupt them. So, yeah. So, can you let us know what types of funds are what types of funds qualify for a set-off?
And let me just clarify, and what I'm talking about here is bankruptcy cases taking place in Florida. So if you have a Georgia or any other state bankruptcy case, give us a call. We can walk through that with you, but I'm going to talk specifically about Florida. So the funds that are available to set off would be pre-petition funds. These are type of funds that are in the member's account prior to the member filing bankruptcy. So the funds cannot post after filing, even if they were trying to transfer the funds into the account. If they haven't posted prior to filing, they are not eligible.
Okay, well then we've got the next step here. What should they do once those funds are pre-petitioned?
So now that you determined that they are pre-petitioned, you need to next see if legally you have the right to set off against those funds. Now, what we always tell our clients is to check your loan documents and make sure that you're legally able to, and that's set forth in those loan documents. So in Florida, there is a statutory right to set off for credit unions. But remember, if you're dealing with a credit card, there must be an additional specific language in the terms and the conditions giving the credit union those rights. So once you receive a suggestion of bankruptcy, or however you find out the member is filed, go ahead and freeze any funds in their checking savings accounts. You have that right. If you have any questions regarding if you legally can, if the questions on the loan documents, give us a call. We can go through them and review them for you.
After they have determined that the funds are pre-petitioned and they have the right to set off, what is their next step?
Well, it depends on what type of bankruptcy case they're in. So we'll start with the Chapter 7. These are known as liquidation bankruptcy cases, and the timelines are a lot shorter than compared to a Chapter 13 case or a reorganization case. So when a member files bankruptcy 7 or 13, the automatic stay will go into effect, so you cannot immediately apply the funds to any type of debt. So in a Chapter 7, let's just say that a member files, has a line of credit with the credit union, has a balance of about $5,000. They also have a share account that has $1,000 in it. So when they file, there's two options at getting to those funds. So the credit union will need to either, one, file a motion to lift stay to get permission from the court to apply those funds, or you can wait until the discharge is entered for the stay to be lifted that way.
So what's the difference between the two?
Well, time and money. Well, a business decision will need to be made on how to proceed. Waiting for a discharge, discharges usually take between 80 and 100 days in a normal Chapter 7 case. So it wouldn't cost anything to wait that time, but it does take a little bit of time. So filing a motion to lift stay will get you access to the funds quicker, but the filing fees for a motion to lift stay will run you roughly $200. So they'll have to decide whether or not it's worth spending the money to get those funds quicker. So if you have a balance of frozen funds of about $500, it may not be worth spending the $200 to get them back.
So what about for the Chapter 13 case? What do you do then?
So if a member files a Chapter 13 petition, and just say there's the same fact pattern as before with a line of credit, balance of $5,000 and $1,000 in the share account, what we would do is file a proof of claim with the court showing that the line of credit is secured for the $1,000 that is in the share account, and the other $4,000 is unsecured. So this means that the debtor has to account for those funds in their Chapter 13 plan.
And so what if they don't?
If the debtor files a plan that does not address for the frozen funds, what we will do is file an objection with the court and force them to address this. Most of the time, the debtor does not address frozen funds in their initial plan that they file with the court. That's usually filed simultaneously with their petition. So once we file our objection, our proof of claim showing that it's partially secured, when they amend their plan, what normally happens is they surrender their rights to the funds. Depending on the district that the case is filed in, the stay may have automatically been lifted based upon the filing of that amended plan. But if it hasn't, what we can do is either move forward with a motion to lift stay or wait until the plan has been confirmed and the stay is lifted that way. So again, at this point, another business decision will be made if the stay isn't automatically lifted as to how to get those funds back.
Do you have any remaining advice on this topic?
Well, as everyone knows, each situation is different. Each bankruptcy case is different. If you see pre-petition funds in a member's account that are subject to set off, go ahead and freeze them just to preserve your rights. You can't go back retroactively and free the funds. So freeze them. You can contact our office and we can discuss and get a plan to move forward and best protect the credit union.
Well, this has been very, very helpful. And I know, as you said earlier in the interview, it can cost them hundreds of thousands, millions of dollars if they don't have this process down correctly. And it is scary to tell someone that you violated an automatic stay, because
Yes.
that just means you're going to get fined, and then your reputation is at stake, and that can mean your business. So I always talk about this, but I mean, for credit unions that feel like they might be able to do it themselves, I mean, and that may or may not be true, but the fact is that if you are not a lawyer, if you're not in court and handling these types of cases specifically for credit unions, then you're probably going to miss a lot. And even missing one thing can cost you. It could cost you your whole business. It could cost you the jobs of everyone that works for you. I mean, it just really affects a lot of people. So I would encourage anyone out there, any of the credit unions that are looking for some assistance on this type of topic or anything else that has to do with credit unions and how they can keep their businesses running smoother and avoid fines and repercussions of not handling these cases properly. Please give the attorneys over at Sorensen Van Leuven a call. They are so helpful, really up to date on the current changes in the law, and they're very friendly. They treat their customers like family, and I can attest to that.
Great. Well, thank you very much, Erica. I really appreciate the time.
Thank you. We'll talk to you soon.